One of the chief architects of the Guantanamo Bay detention facility is now saying the prison should have never been built in the first place. William Lietzau is the Deputy Assistant Defense Secretary for Detainee Affairs. And in an exclusive interview with the Daily Mail over the weekend, Lietzau said it was wrong from the get-go to create this nether region of law at Guantanamo Bay, and that prisoners should have been legally designated as prisoners of war, held in Afghanistan until the war is over, then either released or charged with a crime and taken back to the United States. But that didn't happen. And here we are nearly 12 years later. So how have these flaws in the creation of Gitmo from the very beginning made it so difficult to close the prison today? And what can we do to restore rule of law to the prison that just can't be closed? Joining me now is retired Colonel Morris Davis, former chief prosecutor at Guantanamo Bay and now a law professor at Howard University, and Lieutenant Colonel Barry Wingard, defense attorney at Guantanamo Bay. Gentlemen, thanks for joining me here. As I mentioned in the intro, we have one of the architects, basically, of Guantanamo saying the prison should have never been open to begin with. We should have designated these people prisoners of war, held them in Afghanistan, and then charged people here in the United States. What did we do instead, Colonel Davis?
Well, it was really interesting to read the article over the weekend. Bill Lietzau, I don't know very well, but I've known him for quite a while. And as you mentioned, he was one of the original architects. He was a judge advocate, a military officer back working for the Defense Department when 9/11 happened. So he really was there from day one planning this process that now in 2013 he says never should have happened to begin with. And he seems to be like a number of other officials that shortly before leaving office do a 180 and try to get on the right side of history before they step out of the...
I think it's Dick Cheney. I saw an interview with him and he said that they purposely chose Guantanamo Bay because they could do it outside legal protections that are afforded in the United States. What are some of those rights and legal protections that they've managed to evade by creating Guantanamo Bay?
Well, if you go back, I mean, the whole rationale for choosing Guantanamo was it was believed at the time, which is proven wrong over history, was that it was outside the reach of the law. It was the perfect place to exploit people for intelligence and not to apply the Geneva Conventions, which all of the military services argued we should, as Bill Lietzau said, we should apply the Geneva Conventions, treat these people as POWs, and we had the John Hughes and the Dick Cheneys and David Addingtons who came up with this new category, the unlawful enemy combatant, which is a term you won't find in the Geneva Conventions that we came up with to avoid the law and not call them POWs.
Lieutenant Colonel Barry Wingard, you are a defense attorney at Guantanamo Bay. What exactly does that mean? When do you get called in to defend detainees? How do you fit in sort of the legal system that's been built at Guantanamo Bay?
Well, back in 2008, at the end of the Bush administration, they attempted to put many cases into the process, the military commissions. And when, in so doing, what they did is they entitled these men to defense attorneys, military defense attorneys. Now, to date, there's only been about 30 cases where the men actually have a military defense attorney. So my role is to be a zealous advocate for my clients. I have a Kuwaiti and an Afghani. The Afghani is cleared for release, and the Kuwaiti will be indefinitely detained forever. My job is to go down to Guantanamo Bay and to try to formulate a strategy to gain their release through the judicial system. Unfortunately, it doesn't appear as though any justice is forthcoming in Guantanamo Bay in any way, shape, or form.
So you say that there's been 30 cases, roughly 30 cases brought here?
No, not 30 cases brought. At the end of the Bush administration, they attempted to try to put a bunch of cases into the system. Okay. Now, the majority of those cases, the charges have since been dismissed, as we've seen in both of my cases that I represent the prisoners in.
We're thinking, though, 779 prisoners have gone in and out of this facility. Some are still in the facility. Of those, they've only tried to charge 30 or so with a crime?
Well, no, I mean, in 11 and a half years, we've done 7 completed proceedings, 7. The majority of those 7 have not sustained the burden and have been reversed. So to date, it's my understanding there's about 3 cases where it has sustained and the convictions have been upheld, about 3. That's out of 779 men. Best case scenario, according to the government's own statistics, if all goes right and they get the substandard system of justice known as the military commission that's pro-prosecutorial, they can do up to 20 cases total.
Colonel Davis, you were a former prosecutor at Guantanamo. What does it say that of all these people who've come in and out, they've had only 7 convictions, and of that, some were overturned?
Right, and of those 7, 5 of the 7 are no longer at Guantanamo. So one of the jokes we used to make was at Gitmo, you got to lose to win. Because if you actually got charged as a war criminal and convicted, you right now have a 5 in 7 chance that you're not at Gitmo, where for another 160 some guys, they've never been charged, never convicted, and have no prospect of going home. But it was clearly, again, it was picked as a site that was outside the reach of the law. We created this second-rate system of justice that's been amended again and again and again and again. And each time we've told the world, trust us, this time we've got it right. And we've managed to slug through 7 cases in 11 years where federal courts have prosecuted hundreds over that same period of time. So we need to give up this charade and either prosecute these guys in federal court or start making plans to send them home.
As a former prosecutor who now sees that this facility should have never been opened and operated in the way it did, what caused you to come to that understanding? Well,
again, the military, the uniformed military services were never in favor of Guantanamo to begin with. But the political appointees told us, we had to do it, and so we tried to make the best of it. And I believed when I took the job there were people appointed above me that were committed to trying to do this in a credible way. I mean, I've made the comment before that my generation looks back at Nuremberg with kind of a romanticized view of how we did justice there. And my hope was that my grandkids may look back one day at Gitmo and said, with that same notion. But over time, it's become clear that even now, if they have the most perfect trial ever conducted for KSM, for instance, no one's going to believe it's really justice.
The administration has this list of 46 individuals who've been deemed too dangerous to be able to leave, but they can't really be tried in court because they don't have the evidence to convict them, or the evidence they do have isn't permissible in court. What do we do with those guys?
Well, let me tell you, one of those 46 happens to be one of my Kuwaitis. His name is Fayez al-Kandari. He's from Kuwait. Kuwait happens to be one of the strongest allies of the United States. At the end of the Bush administration, they said, if you build a rehabilitation center, we'll send your sons back to Kuwait. Well, Kuwait went ahead and built a $40 million rehabilitation center. Today, there's 13,000 American troops in Kuwait. So, I mean, I've looked at the evidence in my client's case. I've been studying this case for 5 years. I know virtually every fact in this case. And I'm here to tell you that this man will never get a trial. It's double, triple, quadruple hearsay. It's incredible statements. I mean, they said that he surrendered his passport when he went to Afghanistan. I went to Afghanistan and found his passport. That's when they said, oh, well, no, they changed their strategy completely and said, oh, that just means he's super Al-Qaeda and not a trainee anymore.
Given that, like your client, this is the reason why one of the reasons why the facility stays open. Colonel Davis, what's more dangerous? The 46 individuals who might pose a threat if they're released, or what's a bigger threat to the United States, I should say? Those 46 individuals who might be released to commit crimes against the United States in the future, or just the prison itself remaining open indefinitely?
Well, I think it's the latter. I think this charade's gone on, long enough that, our justification for the indefinite detainees, the ones that aren't going to be transferred home or prosecuted in the military commission, our theory has been that under the law of war, we have the right to detain the enemy for the duration of the conflict. Well, the president said we're pulling out of Afghanistan by the end of 2014. So when we pull out, that whether you agree with the justification or not, that justification evaporates in 2014. So we've either got to find a way to send these guys home, prosecute them, I believe in federal court, or we're going to have to create a new lie to justify their detention.
Gotcha. We'll see what happens. That was Colonel Morris Davis, law professor at Howard University, and Lieutenant Colonel Barry Wingard, a Guantanamo Bay defense attorney.